You would just love.
All right. Board of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Alan Lawson, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As announced, I'm Judge Lawson. I'll be presiding on the two cases we have today. To my right is Judge Palmer. To my left, Judge Cohen. The first case is Collins v. State. It's a criminal case. Each side will have 15 minutes. And if you want to let me know at the beginning how much time you'd like to try to reserve out of your 15 minutes for rebuttal, I'll set the clock so that the yellow light will come on when you're in your rebuttal time. And the same will apply to the second case, which is a civil case, for which each side will have 20 minutes. And whenever you're ready, we're ready to proceed.
Counsel, may it please the court. I'd like to let's do 7 minutes and see how it goes. Your Honors, this case is kind of an interesting criminal case. Always kind of interesting facts and how these things come to play in a jury trial. What we have here is an attack on a lady, and there's really with a knife to the head. And the question is, who did it between my client...
I'm interested in talking about the sixth issue, the judgment of acquittal issue, and,
Sure.
and the Florida Supreme Court case of Moore,
Okay.
which says that a prior inconsistent statement cannot be, and I'm quoting, the sole evidence of a central element of the crime. Is that correct?
That is correct.
And they also said in that case, quoting from Arico, a Sixth Circuit case, that the prior inconsistent statement can be used to corroborate evidence which otherwise would be inconclusive, to fill in the gaps in the government's case, to reconstruct the events, and to provide the details. And my question relates to Ms. Collins' testimony, and I'm reading from the transcript. And unfortunately, the transcript pages are blotted out by the seal from the clerk, but this is at the PDF page, let's see, 267. And my question was, who cut you with the knife? And the victim's answer was, Ms. Collins cut me with the knife on my head, but my head was down so I did not see the cut. So that was her testimony. And she does go on to equivocate and say she couldn't really see, so she's not really sure Ms. Collins was close and that kind of thing. But my question is, why wouldn't that be evidence that would otherwise be inconclusive? She cut me, but I couldn't see it for sure, so that the prior inconsistent statement would simply be corroborating, explaining, adding details to that statement. It seems like that would be fine under the portions of Moore that I've quoted.
Well, it reminds me of that My Cousin Vinny scene where he says, I killed the clerk. I killed the clerk. Did you say I killed the clerk? He says, well, yes, I said that, but, and if you read the complete, that's why I quoted, block quote, the entire statement when the identity is being established by the victim. And she says, as you said, she says, sentence, Ms. Collins stabbed me, but then there's the but. And when she explains how she came about to that conclusion, she says,
Right,
well,
I read everything too, and what I'm saying is, if you just took that statement in isolation, it would be, sure, I mean, you could pass a JOA on that statement alone, but in context, her direct testimony at trial, because of the equivocation, I would say, would be inconclusive. But the quoting from Moore, it says that the prior inconsistent statement can be used to fill in the details and corroborate evidence that would otherwise be inconclusive. So why doesn't that get you past the Moore problem, her direct testimony?
Well, there's kind of 2 points here. One is that you have to read her entire testimony in context. When you make a sentence, and of course this punctuation is driven...
Right, and I'm saying in context, her testimony is inconclusive as to that point.
Do you agree with that? Do you agree that it's inconclusive? Or
Yes.
do you think in the context of the entirety of her testimony that was not inconclusive, that the testimony was fairly clear that she did not know who cut her?
Well, I think she knew it was either Miss Collins or Money, the other woman. It was one of those two. And that, as she explains in her testimony, at the time, she's being told by people through hearsay statements, saying, well, this is who did it, and she was angry, and she had this fight, and so these other prior statements were written in anger. And I think that, there's really 2 ways to look at it, and I guess that's why you have an adversarial system. The one is, well, she was lying, she was lying earlier, and now she's telling the truth on the stand when she says, well, I really can't say, which would be a defense position, and the state saying, well, she's now equivocating because she's looking the woman in the eye and she's afraid or whatever. But I think that earlier context, the first point, is very much consistent with, because, here when she's angry and she's right off and she's writing the statements and people are saying, oh, that woman stabbed you, right? So she's reflecting, and that's what she explains in her testimony. In those prior statements, she's reflecting what other people had said. She knew it was one of the two, and she's angry at this other woman, at my client, so it becomes her. But now, based on the reality of the accusation...
The Moore issue, can't the jury take her explanation in light of the fact that it was clear that she did not want to testify against this defendant at trial? I mean,
I don't think that's, and that's one interpretation. I think there's another interpretation of this, and that is that when she's facing the consequences of her statement and looking, there's a defendant here and there's a great consequence.
Those are great jury arguments, but in terms of a JOA, the straight legal issue, do you get to the jury? What I'm...
Right.
The question I'm posing is, why doesn't her direct testimony get you beyond the Moore issue?
Let's go to that statement.
Her prior inconsistent statements were very unequivocal that it was Pinky or...
But I'm not sure those statements should have come in, because they're basically, the state is impeaching their own witness.
Well, that's the first issue, so...
Yeah, but assuming those come in, the questions, you have two equivocal statements. The full statement is, Ms. Collins cut me on the night with the knife on my head, comma, but my head was down, so I did not see the cut. So I did not see the cut, I just felt it. Money was in close proximity too, so I don't want to say definite it was her. My head was down, I didn't see the knife came from, I just felt the cut. So that is equivocal, and she goes on, and it's very, very equivocal. Now, the state put this very nefarious spin on it, but I think it's just as reasonable, if not more so, that she's coming forward and saying that I'm not sure who cut it, because here I'm facing the reality of a courtroom, a judge, I'm swearing under oath, I'm outside, the emotions have calmed down, and now when I have to point the finger, do you really know who stabbed you? Could it have been consistent with my client's theory, which is that she was being, she came in and she sees this attack, she's surprised by it, she's being held back, give me the knife, as in, give me the knife so she don't cut her, and then Money takes the knife and stabs her.
One other piece of evidence, it seems to me to take this out of the Moore issue, is the statement of identification. The officer testified she identified the defendant as the perpetrator, and that would come in as substantive evidence under the hearsay exception for a statement of identification, right?
Right, but it's all coming from the same person. It's all coming from the victim of the stabbing. And the question is whether or not, based on her equivocation, saying it could have been either Moni or my client who stabbed me. I mean, I don't think I think it's a fair reading. There's no way that her direct testimony can say anything but that she wasn't sure it was Moni. And my client's statement, which is, it was Moni. So now you have, and all these other statements are coming from the victim who testified in the case. So you have an equivocation, an unclear direction, which is consistent with my client's theory of innocence.
But the only JOA type argument you've made is based on Moore, and what I'm questioning is, why don't those things get you beyond Moore and make those issues that you're arguing a jury question?
Right. Well, I mean, I think that Moore says that a prior inconsistent statement is not sufficient evidence. So those are prior inconsistent statements in those affidavits that were provided to the court. Those are prior, so that cannot be the basis alone.
What Moore said is the prior inconsistent statement can't be the sole evidence.
Right, and so then what's the other evidence? The other evidence is her direct testimony, which is equivocal. Could have been either what it was, or it could have been my client's statement, which is that it was this other attacker.
I've used about 8 minutes of your time on that, so if you want to make something else, I'd rather talk about it.
Well, that was 8 minutes. We went to the JOA point. I think as to the assault point, there's clearly a JOA on an assault. Her head is down. She doesn't see it coming. That's kind of classic law school 101. Same thing with the burglary count. Well, and there's a lot of interesting stuff. I think when it rains, it pours on these cases when they're error. Same thing with the burglary count as far as the timing of the amendments go. she was tried on, yellow light, it's just light up. Does that mean I have 1 minute?
Well, that means you're in your rebuttal time.
Oh, okay.
Take that away now that you know that.
There's so much to cover. I think we covered in the briefs. I do think that the statements, you can't pull that out of context, because her statement her direct testimony has to be read in entirety. And she is saying in the entirety that, I'm not saying, she is equivocal. She's saying it could have been my client, or it could have been money. I mean, that's what she says. These other, and then the rest of it is controlled by more. Whether you put a period in a particular place to make the statement stop, I don't think that's a fair reading of the entire testimony of her direct
Would you
testimony.
also look at the cross-examination where she was asked, but you didn't see who cut you, and she says, no, my head was down?
Right. So that's exactly what we're saying. My client was being held back by this gentleman who came in and kind of pushed her back, and then the fight was clearly started between Money and Miss Money and the victim here. Those two people were fighting. My client was then held back. Now the question is whether she came back. Well, her head was down and she didn't see, and I think that's what the facts say. And when she's confronted with this courtroom situation, that's when she's looking and say, well, do I really know this? Did I see this? Or is it possible that my client, Ms. Collins, did the stabbing? And when she looked at it, she says, I think that I have to equivocate because
I
she
do want to
wasn't
give you a
sure.
chance to address this other issue that I have a concern about. On your issue 5, the trial judge, the issue is whether the amendment was a problem because it was basically a new charge because it added a new element beyond the statute of limitations. And the trial judge, in rejecting that argument, said, number one, it wasn't a new charge, it wasn't a new element, and number two, the statute of limitations period is extended 45 days because we swore the venire, we started the trial within the original period, and that gives us the 45 days. Now, on appeal, you challenge that first finding, but you have no argument whatsoever with respect to the second reason why the judge rejected that argument. Doesn't that mean that we affirm because there's no challenge to the
So what was the second reason? I missed that.
The second reason was he said that the speedy trial time restarted because of the swearing of the venire.
Well, I don't think that's true at all. I think
You don't argue that on appeal. You don't argue that he was incorrect.
But they didn't swear the veneer. They swore the veneer. No. I mean, in fact, I addressed that in my reply brief. They had a jury pool that came in. They swore the jury pool. They did not pick a jury. They swore the jury pool.
Yeah, that's the venire. They swore the potential jurors for jury selection, and the rule says that that's what stops the speedy
I
trial.
did address that in my brief. Could I maybe reserve some time and come back with that?
You have about 3 minutes left if you want to save that.
Thank you.
Time flies when you're having fun.
May it please the Court, Anthony Golden with the Attorney General's Office representing the state. While it's fresh in my mind, I'd like to address the speedy trial issue. There was a demand for speedy trial that was filed in November 16th. The judge set the trial date for January 3rd. Then, on December 6th, I believe it was, there was a motion to withdraw filed by defense counsel, and then on the 16th, there was a hearing on that motion. And first off, I don't think the speedy trial, that the defense was ready and available for trial during the period when the defense attorney was moving to withdraw. But we get to January 3rd, and in the record, I believe it's page 167 of the record, the judge says, I swore a jury on January 3rd and declared a mistrial, so we're in a new speedy trial period. So assuming the speedy trial period started running when there was a demand for speedy trial, trial was set for the 3rd, a jury was sworn.
They didn't swear a jury, they swore the panel.
All we have in this record is what Judge Loughton says in that hearing on, I think it was the 10th.
If they actually swore the jury, that would be a double jeopardy problem, I would think. But
All we have is what he said, and there was no correction or objection to what he said at the hearing. I believe it's page 167. if you want to check on that later. But in any event, it's our position that speedy trial had not run as of the 3rd, and I think it was the 48th day, January 3rd. And as for the amendment, there was no surprise as to the amendment. The facts of this case were obvious to everyone pretty much from the start. Whether she came in with the intent to commit the crime or remained in the house afterwards, I think under either version they could have got a conviction. But there was no surprise, and it's our position the speedy trial period had not run. Going back to the judgment of acquittal and the inconsistent statements, it's our position that although she did equivocate at trial, the victim testified that she and the defendant had been friends for years, and there was definite hesitancy at trial in testifying. But she did say at page 32 of the record, "Ms. Collins cut me with the knife on my head."
You got to take that in context. You know, and both immediately after she says that, you know, she continues to say, "So I did not see the cut." Continues on, "I didn't see it on cross-examination. Did you see who cut you? No, my head was down."
She said she saw her with the knife, but she was cut on the forehead, and she didn't see the person with the knife in their hand as they cut her forehead. That does, I think that's the ultimate jury question. But what we also have is the testimony of Officer Coleman.
Let's assume that you had no prior inconsistent statements. You think that that testimony is sufficient for a conviction?
Given the whole scenario as set forth by the defendant and the victim, they both basically agree. There was an argument. The victim told her to come over and...
She says on a number of occasions, both on direct and on cross-examination, "I did not see who cut me." Do you think that that would be sufficient for a conviction?
In this case, with all the other facts involved, yes.
All the other facts. I'm not talking about the inconsistent statements. I'm talking about just that testimony. There were no other witnesses that testified, direct eyewitnesses that testified. No. So you got her testimony. Her testimony is, "I didn't see who cut me."
I didn't see the knife hit my forehead, basically, is what she said.
She was asked or said. She was asked, "So I did not see the cut. I did not see the cut. I just felt it. Money was in close proximity to, so I don't want to say for definite it was her.
Right.
My head was down.
Right.
I didn't get to see where the knife came from." Then on cross-examination, or she goes on in direct examination, "I'm saying it's a possibility. I'm not saying for definite it was her because my head was down."
But she also said, hurry up, let me have the knife." That just proceeded. See, Money had the knife first, apparently, and handed it to the defendant here, SAVONIA, and the victim says, "I saw SAVONIA with the knife." And then she was cut in the head, but she didn't see the actual knifing as it occurred. I think, to answer your question, yes, I think a jury could convict based upon that. But we also have Officer Coleman.
So on cross-examination, when she says, "But you didn't see who cut you," and she says, "No, my head was down," we ignore that.
No, I think in context, yes, she didn't actually see the defendant put the knife into her forehead. She said her head was down and she got knifed. But she also said that she saw the victim apparently a second or two before with the knife. So I think it's reasonable to assume who did the knifing. And she told it when on the day of the incident, she told Officer Coleman, page 85 and 86 of the record, "He arrived at the scene minutes after attack. The victim identified Pinky," who was the victim did testify. Pinky is the nickname for appellant. The victim identified Pinky as the person who had knifed her and signed a written statement to that effect. So on the day of the incident, the victim tells the...
That's not substantive evidence.
No, but it certainly corroborates what what we have, all the other circumstances we have, including the defendant's own version of events. She admits basically everything except that she didn't do the actual knifing or the hitting. And by the way, the same with the striking with the 2x4. Initially, the victim said it was Pinky that hit her with the 2x4. She came down the hall with the baby. And then later on, she's not sure who had the stick, as she referred to it. So we know they're friends. We know the families wanted this to go away. There was talk about, trying to mediate this whole dispute. But the bottom line is her testimony, along with all the other corroboration, was sufficient to get past the judgment of acquittal on these charges. At least that's my position. Are there other issues you wanted me to address while I get...
With respect to the first issue, you can't call a witness for the sole purpose of impeachment. I think the test is whether you have a reasonable expectation of helpful testimony. Explain to me why the state had a reasonable expectation of helpful testimony from the victim.
Oh, I think the prosecutor was surprised by the victim's testimony. She was not called merely to impeach her prior testimony. She was called to testify to what she said in her earlier statements. And I think that our prosecutor below was clearly surprised that she didn't say exactly what she had told Officer Martin. And apparently, that's what brought about this whole thing about the telephone calls from the jail and getting Uncle Duke to help try to mediate this dispute and get her to the attorney. Maybe she'll drop the charges. All that stuff explains why there was some hesitancy when she got to trial in being more definitive as she was initially. So,
You think that the state presented evidence that the defendant in this case was either involved or aware of attempts to threaten or tamper with the witness?
no, as a matter of fact, the victim testified she did not feel threatened, that the defendant never threatened her. And
So why then would any of that have been admissible?
Well, I think it explains what happened here. I think the phone calls to try to get her to drop the charges would explain.
The state can present veiled evidence of threats, that's admissible into evidence to put her testimony in context? I'm surprised
I disagree with the characterization of veiled threats. I think there was attempts to, as in a lot of these family dispute cases, where everyone hopes the whole thing goes away.
They were friends, they weren't family.
Well, Uncle Duke and Uncle Pap, apparently they're all they're friends or relations. But to answer your question, the only objections to this redirect testimony, which was characterized as being riddled with hearsay, were the prosecutor asked the victim, "Did you feel threatened by the defendant?" Objection beyond the scope of cross-examination. Answer the victim was then no. So that's not a hearsay objection. The next question was, so at some point, someone in the defendant's family, did they make you feel threatened? How does the victim feel? That's not hearsay. She testifies, no, I did not feel threatened. There was no request for a Richardson hearing about the male cousin who was supposedly threatening her, but apparently the prosecutor at some point, I think it's page 48 of the record, says the defense was aware of these threats against my victim since the day of the bond hearing. So everybody knew all about this apparently. And
Well, the issue that's framed in the appeal, issue 4, is whether the prosecutor's argument that there were threats was improper, and what you're telling me now is apparently it was improper because there was no testimony or no evidence that would have supported that argument. And the law is, with absent evidence to show witness or victim tampering, you can't argue that to the jury.
Initially, apparently, according to what we have before us, the record that we have, is there was evidence of threats presented at the bond hearing. As for what it was testified to at trial, the victim said, no, I did not feel threatened.
Prosecutor from arguing that there was pressure put on and there were threats made against the victim that affected her trial testimony.
Well,
I mean, that was the prosecutor's argument in closing, right?
well, I read it a different way. I read it that what the prosecutor was essentially saying is that they tried to get her not to prosecute this case, that they wanted this to go away, that there was an attempt to mediate this dispute between them, and that basically the uncle was saying, you could be in the same situation she's in. So I don't think, when you look at the fundamental error in prosecutorial closing argument, the question is, did that argument affect the verdict? And in this case, I think the evidence was pretty clear. The two women came in together, acted in concert, whacked the girl with the 2x4, then they grabbed a knife and there was a tussle and the victim was knifed. The two of them were basically acting together. Now, the defense was that Money, the other girl, was acting alone, and that our defendant was just turning on the television and had nothing to do with it. Well, it doesn't seem to make any sense.
The state's theory to the jury wasn't that they acted in concert, it was specifically that the defendant did the cutting, right?
Shanique, the victim, initially said it was Pinky that cut me, and then she said the same thing at trial, but then she equivocated by saying, but my head was down, so I didn't actually see her with the knife when she
The state's
cut me.
argument to the jury wasn't some kind of principal argument, right? That they were both in concert and therefore she'd be liable regardless. It was that she's the one who...
No, it's not, the argument was that they had attempted to mediate this, basically, at least that's the way I read it.
No, on how the crime occurred. The state's argument to the jury wasn't, it doesn't matter which of them struck her, they were acting in concert. It was specifically that the defendant did the cutting, right?
The initial statements the victim made was that Pinky whacked me with the 2x4 and then she stabbed me with the knife. Later on, she equivocated, she's not sure who
The
did.
state argued to the jury was
Right.
not a principal theory, right?
Right.
This is not material, but since you have a few seconds left, and I'm curious, as I read the testimony, she kept saying the stick. Was there testimony that it was a 2x4?
Yeah, it was
keep saying 2x4.
written in the information as a 2x4, and there was a reference to it. But the parties involved, the victim and the defendant, referred to it as a stick.
Okay.
Thank you. We'd asked you for...
That was I wanted to get to point 4.
Very quick question. On the assault argument that you made earlier, was that argument made below? That there was that she wasn't put in fear because her head was down? Was that argument made below?
I'm not sure,
I don't
actually.
think it was.
Okay, I'm not sure about that, but it's kind of a side argument.
Respond to what you wanted to respond to.
Right, I really want to get to point 4, because that, in fact, I kind of thought that, I was surprised when the state came over, I shouldn't surprised, I was pleased that the state came back and pretty much conceded 1 through 3 did not establish any basis for any kind of accusations of witness tampering. And I would like to direct your attention to the reply brief in the Appendix A, which I attached the complete closing arguments of the state, in which front, beginning, middle, and end is rife with accusations of witness tampering. And in fact, that puts it squarely in the Penalever and this court's case in Tyrone Jones versus State, which are cited in the brief, which says that is very improper. And I would say that the closing argument in this case is way worse than either one of those cases. I mean, this is the entirety of the closing argument is the statements by the prosecutor that the reason the evidence didn't come out the way they expected to come out was because the victim had been tampered with. And I mean, she goes on, it's pretty clear why they came out they did. We know someone had power over her. The defendant used her family to pressure Ms. Martin to essentially drop the charges. That's not justice.
Was there an objection made to this?
And there was not, but I would point you, and this court has...
So there were 2 jail calls that were introduced into evidence.
Right, which you have before you.
And the first one, the defendant was asking her uncle, Duke, and her father to take Martin to the state attorney's office to get the charges dropped, basically. And in the second one, she wanted to get everybody on the same page and wanted to make sure that Uncle Duke was in the courtroom when the victim was. That would take care of it, which to me implies an intimidation, that she's coordinating her family members to affect the witness. I mean,
Well, it's interesting, that's kind of...
why wouldn't her own statements in those calls be sufficient to support the argument of the prosecutor?
Well, that's kind of why the state conceded this point. I think the state is saying that there is no evidence of witness tampering, and the point that you're talking about, the jail calls, and that's what point 3 addresses. My client was not allowed to fully address that point. She was allowed to address it somewhat, but the fact is that was in relation to a bond hearing, and there was nothing nefarious about those calls. I mean, you can look at something, the fact that she's talking about her case on a jail call and talking about, gee, well, the victim here is saying I didn't do it. Why don't you get her down to the state attorney's office? I mean, isn't that what an innocent person would do? I mean, I don't think that's a tampering. That's an effort to get the information to the state.
It looks like those statements could be, I mean, your client wants to explain them that way as innocent. The state wanted to argue that they were not innocent, that they were evidence of her involved with her family and attempting to change the outcome of the case by tampering with the witness. I mean,
well, the appellant,
isn't that a reasonable reading of those calls? It's one possible explanation.
I don't think so. I think the appellee, and I'd encourage you to listen to those calls, the appellee has pretty much conceded that we're in point 4. The question is whether or not it's, there's a preservation argument, and I direct your case to the Gus Kaminsky case, which is cited in my initial brief, as to why this is basically that points 1, 2, and 3 had already gone against the defense counsel, and it would be pointless to continue to argue that point when that stuff had already gotten in. Now, appellee then concedes that there is no factual basis to argue tampering, and then we have front, beginning, middle, and end, and they're usually...
Too carried away with it, because we don't really care what they concede and what they don't concede. We're going to look at this, ourselves, and
Okay.
And so, Judge Lawson's bringing up these phone calls from the jail, so the question
Okay.
is, do they support that theory of pressure being put on the victim?
I don't think, I listened to him, and I can't see how you could, unless, I mean, it's kind of one of those, you put the state hat on, and somebody who sees everything through a guilty lens, or somebody who sees it through an innocent lens. I guess we have the adversarial system. I listen to those calls, they're just talking about, she says, oh, so the victim here says
The jury did, too.
I'm sorry?
The jury got to look at it, and their lens...
It's before the court. I mean, we have it in the record. I supplemented with it for that very reason. Because, I mean, if it had come out and said, I want you to go get Duncan Duke and make sure it wasn't that. It was, oh, so she says that I didn't do it. Well, make sure the state attorney knows that. Go talk to the state attorney's office, get her down there, because I'm in jail and I'm facing these charges when she says I didn't do it. Inform the state attorney's office. Isn't that a reasonable thing for somebody who's sitting in jail and something they didn't do to ask for? I mean, to construe that and say, well, that's tampering.
Thank you very much.
Okay, thank you, Donna.